Hello live law viewers. Welcome to Courts Today. Let's dive into the important legal headlines of the day. RJD MP Manoj Jha approaches Supreme Court against Waqf Amendment Act 2025. Supreme Court calls fresh report from Union and Bihar governments on steps taken to remove illegal encroachments from Ganga River banks. Delhi High Court dismisses PIL for regulations to protect peacocks dying of electrocution. Minor victim's mother approaches Supreme Court challenging Allahabad High Court's controversial ruling on rape attempt. While upholding penalty of compulsory retirement, the MP High Court has held that guard posted at High Court judge's home consuming liquor on duty is serious misconduct. Supreme Court flags lengthy pleadings and use of AI-generated statements, asks courts to strike out unnecessary pleadings in civil suits. Jammu and Kashmir High Court notifies video conferencing Naya Shruti Rules 2025 to eliminate delays in court proceedings. I'm your host Syed Amir Hussain, bringing you the important legal updates of the day. Quick, crisp and to the point. Watch till the end, and if you find this update valuable, don't forget to like, share and subscribe. Your support keeps us going. Before I get to the details, here's an exciting opportunity for judiciary aspirants. Live Law Academy, Live Law's Judiciary Coaching Initiative, has opened registrations for its May batch. Choose from tailored courses. JSEP 2.0, a comprehensive 18-month online program covering everything you need to crack the judiciary exam, taught by an expert panel, including retired judges. JSEP Lite, a flexible, weekday-only program for those who prefer a structured yet lighter approach. Sign up by April 10th and get an exclusive 30% early bird discount. Plus, enjoy free Live Law subscriptions, case compilations, and much more. Don't miss this opportunity. Enroll today at www.livelawacademy.com. MPs Dr. Manoj Kumar Jha and Fayyaz Ahmed, Member of Parliament from the Rashtriya Janata Dal representing Bihar, have filed a writ petition before the Supreme Court challenging the constitutional validity of the Waqf Amendment Act 2025. The MPs argue that the amendments violate fundamental rights guaranteed under Articles 1, 14, 15, 21, 25, 26, 29, 30 and 300A of the Constitution. The petition states that the amendments erode the original legislative intent of the Waqf Act 1995, weaken the administration of waqfs and enable excessive government interference in Muslim religious endowments. One of the central challenges is the elimination of the concept of waqf by user from Section 3R. Waqf by user, a principle upheld by courts, recognized that long-standing public usage of property for religious purposes could itself constitute a valid waqf, even without a formal deed. Petitioners contend that by mandating a formal deed, the amendment jeopardizes a large number of historical waqfs and opens them to legal challenges. The petition also criticizes mandatory inclusion of non-Muslim members in the Central Waqf Council and state waqf boards, the removal of the requirements that the chief executive officer of a waqf board be Muslim, powers granted to authorities to unilaterally declare waqf properties as government property, the restrictions preventing scheduled tribe members who convert to Islam from creating waqfs, and narrowing of waqf creation to individuals who can prove 5 years of practicing Islam. The MPs argue that these provisions dismantle denominational autonomy and intrude into minority management rights protected under the Constitution. Stay tuned as the Supreme Court is set to hear the matter. The Supreme Court has asked the Union and Bihar governments to submit detailed reports on illegal encroachments along the banks of the Ganga River and the steps taken to remove them. A bench of Justices J.B. Pardewala and K.V. Vishwanathan said it wants to know the number of existing encroachments, how authorities plan to remove them, and within what timeline. The court was hearing an appeal against a 2020 NGT order concerning illegal constructions like colonies, brick kilns, and even a road built by Bihar government on the floodplains of Ganga in Patna, an area known for being a rich habitat for freshwater dolphins. The appellant, a Patna resident, raised concerns about the rising encroachments threatening the river's ecosystem and the city's drinking water, which is already affected by arsenic contamination. The court had earlier directed the Bihar government to stop any further construction near the Ganga and indicated that it may widen the case to include floodplains in other states as well. The matter will now proceed after the governments file their responses. The Delhi High Court has today dismissed a public interest litigation filed by Save India Foundation seeking regulations to prevent peacock deaths due to electrocution in the national capital. The petition had alleged that peacocks, India's national bird, were being electrocuted due to exposed electric poles and wires, and there were no regulations or standard procedures in place for their protection. A division bench of Chief Justice Devendra Kumar Upadhyay and Justice Tushar Rao Gadela said the court could not legislate or frame regulations and directed the petitioner to approach the appropriate authorities instead. The court noted that a representation had been made only recently on April 3rd to the Department of Forests and Wildlife and other officials, and questioned the petitioner for rushing to court without waiting for a response. We may have sympathy with your cause, but cannot encourage such petitions, the Chief Justice said, emphasizing that courts are not magic wands and can only intervene if authorities fail to act. The bench underlined that correct authorities must first be approached and given reasonable time to respond. During the hearing, counsel for certain DISCOMs also pointed out that no representation had been made to them. Ultimately, the court dismissed the petition but granted the petitioner liberty to submit a detailed representation within 2 weeks. Authorities, the court said, must consider and act on such representation as per law. The Supreme Court on Tuesday heard a petition filed by the mother of an 11-year-old victim challenging a controversial Allahabad High Court ruling which had held that grabbing a minor's breasts, breaking her pajama string, and trying to drag her under a culvert did not amount to attempt to rape. The High Court's decision had caused massive public outrage, leading the Supreme Court to suo motu stay the ruling, criticizing it for showing a total lack of sensitivity. The judgment was delivered after 4 months of deliberation, but the Supreme Court said it displayed an inhuman approach. Today, a bench of Justices B.R. Gavai and Augustine George Massey tagged the mother's petition with the suo motu case and directed that the victim's name be redacted from High Court records. Earlier, the trial court had summoned the accused under serious charges, including attempt to rape under the POCSO Act. However, the High Court diluted the charges to lesser offences like assault with intent to disrobe under Section 354B IPC, drawing a distinction between preparation and attempt. The Supreme Court had already expressed strong disagreement with this interpretation, and Solicitor General Tushar Mehta called the High Court judgment shocking. The Madhya Pradesh High Court has upheld the compulsory retirement of a guard who was posted at a High Court judge's residence after he was found under the influence of alcohol while on duty. The court observed that consuming liquor during duty hours constitutes serious misconduct, particularly for someone entrusted with the duty of protection. Justice Gurpal Singh Ahluwalia dismissed the petition challenging the compulsory retirement. The incident occurred when the petitioner, posted as a guard at a judge's bungalow in Gwalior, was found sleeping during duty hours. Upon being woken up by the judge, it was noticed that he was under the influence of alcohol. A subsequent medical examination confirmed the presence of alcohol in his breath, although it recorded that he was not fully intoxicated. The petitioner defended himself by claiming that he was unwell and had consumed cough syrup which might have contained alcohol. He contended that the doctor only noted the presence of alcohol and not liquor in the medical report. However, the disciplinary authority found the charges proved and ordered his compulsory retirement, which was upheld in appeal and mercy petition proceedings. Before examining the factual matrix, the court referred to the settled position of law on the limited scope of judicial review in departmental inquiries, emphasizing that unless findings are based on no evidence or are perverse, courts should not interfere. The High Court noted that the medical report explicitly mentioned the smell of alcohol in the petitioner's breath and found the presence of alcohol. No challenge was made to the doctor's testimony on this point. Thus, the court held that disciplinary findings were based on evidence and could not be interfered with. Further rejecting the argument regarding disproportionate punishment, the court held that the duty of a guard requires a high level of vigilance, and consumption of alcohol on duty gravely undermines this trust. The court observed that while the petitioner might not have been fully intoxicated, the very presence of alcohol in his breath indicated recent consumption, making the misconduct serious. Accordingly, the court concluded that the punishment of compulsory retirement was justified and dismissed the petition. The Supreme Court has raised serious concerns over the increasing trend of long and bulky pleadings in civil trials, warning that it leads to unnecessarily lengthy judgments at both trial and appellate levels. A bench of Justice Pankaj Mittal and Justice S.V.N. Bhatti made these observations while deciding a case involving tenancy rights under the Bombay Rent Act 1973. In this case, the plaint itself ran into 8 pages, while the written statement was a detailed 16 pages. This led to an extensive trial, excessive oral evidence, and voluminous judgments. A situation the court said could have been avoided if the core issues were captured briefly. The court also flagged a newer trend: the use of artificial intelligence or AI to generate computer-drafted statements, noting that courts are increasingly confronted with such AI-generated pleadings. Stressing the need for judicial efficiency, the bench advocated the use of Order 6, Rule 16 of the Civil Procedure Code, which allows courts to strike out or amend any pleadings that are unnecessary, frivolous, vexatious, or amount to an abuse of process. The court emphasized that the trial judges must play a proactive role in controlling pleadings at the initial stage itself. Brief and concise pleadings, the court said, would enable judges to deliver stitch-in-time judgments, preventing delays, easing the burden on higher courts, and ultimately helping to reduce case backlogs. The High Court of Jammu and Kashmir and Ladakh has taken a big step towards digitizing the justice system by notifying the video conferencing Nyaya Shruti Rules 2025. Issued by Registrar General Shehzad Azim, these rules pave the way for extensive use of secure electronic communication in court proceedings across the Union territories, in line with the Bharatiya Nagrik Suraksha Sanhita 2023 or the BNSS. Recognizing delays caused by physical absence of parties, the new rules allow accused persons, except at first appearance, witnesses and experts to attend court via video conferencing. The court can now record pleas, frame charges, and hear cases virtually, with all proceedings via video link treated as fully valid. The system will use High Court-approved platforms equipped with end-to-end encryption, identity verification, and strong privacy safeguards. Each courtroom will have trained coordinators to manage virtual hearings, and breaches of the rules will invite legal consequences. Infrastructure upgrades like dedicated VC centers in districts, police stations, and prisons are also planned, ensuring high-speed internet, LED screens, and secure communication tools. Special support like sign language interpreters and translators will be provided for vulnerable witnesses to make the process inclusive. Public access to virtual hearings will continue unless the court orders otherwise, maintaining the principle of open courts. The Nyaya Shruti Rules 2025 replace the earlier 2021 rules but protect any actions taken under the old system unless they clash with the new framework.